your eyes now, but I know there's always a way. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything much smoother again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. The connections might be tangled, the power source has lost its spark, but every wire tells a story, and I can mend what's torn apart. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. When the current isn't flowing, when the signals disappear, I'll be here with tools and patience, make the static crystal clear. Every cable, every circuit, every problem that you bring, I'll restore what time has broken, make the whole world sing. So don't you worry about tomorrow, don't you stress about today. I've got maintenance for your troubles, and I'll chase them all away. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. Hey, Daniel, everything's good as new. Hey, Daniel, I'll fix you up for you.
Well, welcome to the show. I am your host, the Honorable Daniel Lucas. Today is the UK Supreme Court. Because I'm sure everybody is interested on how that actually works. What's the difference between the UK Supreme Court and the United States Supreme Court? I think these guys actually do their job. But let's get started with that. So let me share screen. Do that. Make this bigger.
Hearing in the appeal to the Secretary of State for Housing, Communities and Local Government and another.
Mr. Harwood.
My lady and my lords, I appear with Mr. Dobson for the appellant, Marcus Dill.
Yes.
Learned friend, Mr. Elvin and Mr. Williams appear for the Secretary of State, and Mr. Hunter appears for the local authority.
Yes.
What I wish to do, my lord, is to explain firstly the impact on Mr. Dill of these proceedings, and then draw attention to a few points in the agreed facts. Then take the court through the key parts of the statute in terms of the 1990 Act, and then turn to my submissions on issues 1 and 2. But before I do that, we say three things. First of all, that the planning regime allows an owner on an appeal to the minister on either a listed building consent application or against a listed building enforcement notice to raise the question whether the item on the list is a building. Secondly, this ability reflects the need for an individual affected by an administrative decision to have an opportunity to challenge it, particularly in resisting proceedings which are brought against them, unless Parliament has legislated otherwise. And the third point, my Lord, is in respect of issue 2, that the approach to what is a building under the Listed Building Act is a property law one of the degree and purpose of annexation. And so chattels, which is what the inspector found that these items were, are not buildings.
I mean, as I understand, the test for whether it's a building is different from the general test for whether it's land. So to say, usually chattels is used in contradistinction to land, but that's not the relevant contradistinction that we're concerned with. So just the mere fact that the inspector said they're chattels doesn't necessarily answer the question whether it's a building or not, does it?
Well, my Lord, the dichotomy in the cases is between something which is either land or a fixture is being part of the land, or a chattel on the other hand. I have in mind Elitestone and Morris.
That's the dichotomy in general law, but we're concerned, aren't we, with the dichotomy between buildings and things which are not buildings?
Well, I would like to have that explored. I think that's going to be one of the important issues to look at, is what we actually are concerned with, without wanting to sort of preempt the discussion. I mean, can I also just ask you this? What are we actually talking about here? I mean, as I understand, we're talking about 2 vases, basically. 2 lead vases, which are sitting on 2 limestone plinths.
Yes, my Lord.
I mean, you talk about them as items, but is there any intrinsic interest in the plinths? I mean, I know they're 18th century, but I mean, it's the vases which are the things which are remarkable and no doubt fetch £55,000. Isn't that right?
My Lord, they were sold together, as
Yes, I know.
one would expect, but one would have thought that the lead fenials were the more interesting of the 2 elements.
Yes, but I mean, if you call them fenials, sure, the fenials are the sort of flames at the top, aren't they? I mean, maybe anyway, whatever they're called, if they'd just been sitting on the ground, would the same points have arisen?
Yeah, but my Lord, we refer to them as fenials as the understanding which we have in the history, and the court may, to illustrate what we have in front of us, the court may wish to turn up in the core bundle MS page 209, which
I think most of us have probably looked at that.
Which are the auction particulars. That the fenials, or urns, however one wants to describe those, were cast at the start of the 18th century, and then about 30 years later were placed on the limestone slab piers.
It says Van Nost piers and fenials at the top of the page.
Yes, my lady.
Well, the
But
other piers Van Nost?
Having a sugar slight uncertainty from our auctioneer, there's a little bit. What is certainly the view that they are of 2 separate dates. That the fenials were right at the start of the 18th century, and the piers were late 1720s, 1730.
So I don't know whether Van Nost was still around then.
Lord, if you forgive my interruption, middle of page 211, Plinth were added in 20 and are attributed to Van Nost according to the auction particulars.
But I knew they were in the particulars. Okay, but never mind.
But my Lord may be right to sort of draw attention to the interesting element of being the lead finials or urns more than the piers. And of course, the nature of these was that the finials were resting on top of the piers, which were then resting on top of slabs.
Well, Mr. Harwood, you've been a bit distracted. So I suggest you rejoin the main road.
Delighted to do so, because what I wanted to emphasize at start is that at the heart of this case is the very real issue of garden ornaments, and that really is what they were and are, which have moved with a family from house to house over the years, then being fixed in place by listing, a listing which the family was unaware of until after the items had been sold. And the issues which arise, whilst I talk of garden ornaments, and there are interesting legal issues that arise, the issues which arise personally for Marcus Dill are significant. There is, if these are buildings not covered by the listing, potential criminal liability for the original removal. An enforcement notice requiring the return of the items, which of course he no longer owns and which appear to be no longer within the UK. Potential criminal liability for breach of the notice if they are not returned. The potential confiscation of the sale price under the Proceeds of Crime Act, and the items becoming referred to as tainted cultural objects under the Dealing in Cultural Objects Offences Act, which means that a person who subsequently deals with them, sells them, or imports or exports them, for example, may be committing a criminal offence in that process. So
I have to say, I hadn't thought about confiscation under the Proceeds of Crime Act, and perhaps my reading has been deficient. I didn't see it referred to in the cases.
My lord, it's picked up in the grounds of appeal in the narrative. To give my lord the reference,
yes,
it's MS page 19, paragraph 36.
Very well. Well,
apologise. It doesn't make.
I don't think it's in your case.
It didn't make it into the later case. No. I'm sorry.
Okay.
That's why my lord might have picked it up.
Okay.
But central to Mr. Dill's challenge is the point which the inspector refused to deal with. Are these buildings, and are they so able to be listed? Mr. Dill has sought to raise this issue by the routes which are, we say, quite appropriate by appeal, and it is still not been addressed. That process, which of course has been going on for almost 5 years now, is one which is a considerable drain on Mr. Dill, both financially and emotionally. So the court will be aware of the importance of these issues. Mr. Dill, can I turn then to deal, first of all, I'll deal with the background, and then I'll take you to court to the statutory scheme, and then more fully into ground one. The facts are not in dispute. I just want to emphasize a couple of matters. The items, and we've discussed their 18th century history, were at Rest Park until 1939. And then they moved around with Mr. Dill's family as garden ornaments. So taken away in 39 to Coles Park in Hertfordshire. Then in around 1955, 56, the Dower House at Buntingford. In 1962, they went to Badger's Farm at Idlicott, and finally to Idlicott House in 1973. They were listed in 1986. There is no evidence that the family were consulted prior to the listing. And the court will note that the list description is very sparse. Refers to them as being 18th century, but it is none of the history, none of the attribution to Van Nost, none of the connection with Rest Park. which suggests that the family weren't consulted, because those are the sort of matters which, were they to be listed, you would expect to find within the listing to explain the provenance of the items and so on. The post-listing procedure, we do know, was wrongly handled, at the very least to this degree, that there is a requirement that when an item is added to the list, building is added to the list, it is added to the local land charges register. That took place 6.5 months after the listing, of course, long before the immediate events. But something had gone wrong there. There is no evidence that notification was given to the owner and occupier of the item. So when it came to the subsequent sale of the items in 2009, I said by specialist auctioneers, they were unaware of the listing. There's nothing secret about that process. A copy of the catalogue was sent to English Heritage, who are the custodians of West Park, as whether they might be interested in buying, but nobody picked up at the time of the sale the listing. It's in 2015 that the council become aware of the issue. They threatened to enforce. Mr. Dill says, amongst other points he would raise, that they were incorrectly listed and that they weren't buildings. The council's response is to say quite correctly that government policy was not to consider delisting requests when enforcement was in prospect. The court has that letter, the 22nd of May 2015, at Core Bundle, page 230. So Mr. Dill was steered towards taking these issues through the appeal process. He applied for listed building consent, that was refused. He appealed that. A listed building enforcement notice was then issued. And in both of those proceedings, he raised in essentially identical terms the building point. Now, the council, in the appeal, which was dealt with by written representations, so no hearing, inspector considered the paperwork and conducted a site visit. The council did not take issue with the ability to raise whether or not the items were buildings. The council's comments, and the court has those in core volume 2, page 263, paragraph 6.2, was that as to whether they were buildings, the authority defers to Historic England and its expert.
Sorry, Canning, where are we?
I'm sorry, my lord, MS page 263.
Yeah.
I may have said it the wrong way round, which in the core volume, and these are the council's written representations.
Yes, paragraph.
Page 6.2. So they say that the professional judgment leading to the listings was that they were capable of listing as buildings. The council strongly contend that the original professional assessment and opinion should stand unless and until such time as countermanding professional submissions are made. So the council's allowing...
So they deferred to Historic England, and they seem to refer to a professional judgment made in 1986. Did Historic England make any contribution to this appeal, explaining why they thought they were buildings?
The contribution, the only contribution which Historic England made were written representations which, thank you, the court will find at page 250, which were comments on the listed building consent application.
But do they comment on whether it's an issue as whether it's a building?
They don't, my lord. And whilst, of course, the historic England representations will have been in front of the inspector in the appeal in terms of what they submitted originally, they made no representations in the appeal process itself.
I mean, is it right? We've never had any reasoned explanation from historic building why they think these are buildings.
No, my lord.
Thank you.
And the original listing files, which led, I'm assuming, to English Heritage, as it then was, advising the minister, and the minister then including the items as listed buildings in 1986, those are no longer available. So we don't know to what extent any of these issues were, in terms of from the direct documents, whether any of these issues were considered at the time. The inference of the lack of reference to provenance suggests that the Secretary of State was unaware that the items had only arrived at Idlicott 13 years before they were listed.
I mean, even now, we haven't had any explanation, or Mr. Dill has not had an explanation as why anyone thought these were buildings.
That's correct, my lord.
Well, Mr. Elvin's looking, will now fill us in due
We're here in due
course.
course. So the court will have seen the inspector's response to this issue, which was to say they're on the list, therefore they are listed buildings, and you can't consider whether or not they are buildings. And I won't take time taking the court through that, but it's common ground, Mr. Elvin's submission. The inspector did not consider whether or not the items were buildings. He rested on the fact it was in the list. It's also not contended by my learned friends that had the inspector considered the question, he would have been bound to conclude that the items were buildings. There's no simplex argument that, well, if the issue had been addressed, Mr. Dill would have lost within that. We'll come on to the merits of the issue more under issue 2, but suggests it's common ground that parties accept that there is an issue here. Are these items buildings? Which has then not been addressed in the appeal process or, as my lords pointed out, by any other means. That was all I was intending to say on background. Can I take the court to the legislation? And I'm going to concentrate on the 1990 Act, because first of all, in terms of appeal procedures, it's the 1990 Act which prevails. And in terms of the definition of buildings, there's no difference in substance. So the court will find that at tab 1 of the authorities bundle, MS page 270. And what I want to address are the listing process, the definition of a listed building, the consequences of being on the list, and the Secretary of State and Inspector's jurisdiction on the appeal. I'm going through that, end up picking up some points in respect of both issues whilst I'm doing that, but we'll leave most of the case law until I reach my later submissions. So if the court goes, first of all, to MS 271, the Secretary of State under section 1.1 shall compile lists of buildings of special architectural or historic interest. And in the final line of that subsection, may amend any list so compiled or approved. And that provision, may amend, is the only statutory provision for giving the Secretary a general power to either add to the list or to take off the list or to amend what's on the list. And that is a power that's then picked up subsequently, we'll see, in the appeal provisions. Section 1.3 Secretary of State may take into account not only the building itself, but under B, desirability of preserving, and I'll skip, man-made object or structure fixed to the building or forming part of the land and comprised within the curtilage of the building. So drawing a distinction there between object or structure and potentially the building itself. Subsection 4, an obligation to consult with the Historic Monuments and Buildings Commission, that is known as Historic England, used to be known as English Heritage. So they have to be consulted in England, and the Secretary consult, as appear to him appropriate, persons with special knowledge or interest in buildings. So potentially the National Amenity Societies like the Georgian Group or Victorian Society. There is no obligation to consult or even to consider consulting the owners of the land or the owner of the building, or even for that matter, specifically the local planning authority. So it's a process which at least runs the risk of being unfair and uninformed, because the Secretary of State may make a decision without having derived information from the landowners about that. That so, it sounds as potentially unfair, and without having taken into account information which the landowners and potentially other persons are able to provide. The process looked at as a whole.
I mean, there's nothing wrong with that if the object of the legislation is to ensure that people don't jump the gun by knocking the thing down before you've listed it. But as long as there's a procedure for challenging it afterwards.
Absolutely, my Lord's right. The process works and only works if somebody who is affected is then able to challenge it afterwards. And to bring to the attention of the minister the matters which the minister might not have found out in that process. And we say actually that the regime enables that to be done. But it's important that there's then that further stage. Section 1.5 is the one we will, I'm afraid, spend some time over. I'll just deal with a couple of points on that as it's structured at this stage. First of all, subsection 5, a listed building means a building which is for the time being included in a list. So to be a listed building, before we come on to the A and B, it needs to be a building and it needs to be included in the list. It's not sort of anything that's on the list, it's a building that's included in the list. What is then added, and in part this will be covered by a building in any event, are A, object or structure fixed to the building, B, any object or structure within the curtilage which is pre-1st of July 1948, which is, as the court may know, year zero for planning lawyers. In that the 1947 Town and Country Planning Act came into force on that date.
Yes, we were trying to find where that came in. I mean, our researchers suggest that the reference to objects and so on came in 1968 as a response to the Cawthorne case, dealt with the problem of fixtures and so on, which we'll probably be coming to.
Yes,
Is that right?
My Lord's right, that's our conclusion as well. And
It wasn't in the 47 Act.
It wasn't in the 47 Act or the 1962 Act,
Yeah.
which was the subject of the Cawthorne litigation, where the court was just dealing with is building simpliciter. It's then introduced in the 1968 legislation.
And that part, at least, does appear to be introducing land law concepts, I think.
Yeah.
Is that right?
And the concept of curtilage. So the A and B get introduced in 1968, and then find their way into the 1971 Act and through into the 1990 Act. In essentially the same form. The one change that does occur is that in the 1968 legislation, the 1948 cut-off date wasn't included.
When did that come in?
That came in the Housing and Planning Act 1986, and we picked up the reference to that in our written case, and I'll pass the court. I'm obliged. It's court bundle page 73. So the first footnote on that page, the 1948 cutoff is introduced. So, my lords, page 73 in the core volume.
Where am I looking at the?
Which is in the case for the
I've got
appellant.
page 73. Where in the
Page 73, footnote 1, my lord.
Yes. I see. So, I mean, this particular item would not have qualified as under the Kirchenage provision because it came there after 1948.
Because it's post
So it's sort of
1948.
being brought in as a sort of separate building in its own right.
Don't know what the rationale was, and we would say it wouldn't have been caught by the Kirchenage provision for a further reason, which is that it's not part of the land. But that issue would have had to have been raised.
Yes, well, that would be a pure land issue.
Yeah.
Wouldn't it? But I mean, if you had a case where there was an issue about whether it was pre or post 1948, Mr. Elvin's case, you wouldn't be able to raise that by appeal to the Secretary of State, would you?
Well,
You would have to do it by judicial review.
we'll see how Mr. Elvin puts his case. My lord,
I mean, a purely
Except the-
factual
the
issue
ex-
about whether it was being put there
Yeah.
before July 48 or not. As I understand his case, you would have to somehow do it by judicial review.
well, my lord, our view is that that's the point which can be taken on appeal, and on an associated aspect of curtilage listing as to whether or not something is ancillary, is a structure in the curtilage listing needs to be ancillary to the main building. That was a matter dealt with by the High Court in Chambers and Guildford Borough
Yeah.
Council,
Yeah.
which took the view that the appeal process is precisely the way of resolving those issues. I'm going to come back to section 1.5 more in due course, as the court may have anticipated. But it's worth just having in mind that in terms of the definition of building itself, just perhaps for the court's note at this stage, section 91, subsection 2 applies in the list of building acts. Following expression has the same meaning as in the principal acts. It is page 321. So, except insofar as the context otherwise requires, following expressions of the same meaning as in the Principal Act, which is the Town and Country Planning Act 1990. That includes building, and the definition of building in the 1990 Town and Country Planning Act, we find
393 possibly?
393. My lord's ahead of me. So section 336. Building includes any structural erection, any part of a building, but does not include plant or machinery comprised in a building.
Sorry, what page was that?
It is page 393, my lady. which is section 336 of section 1 of the 1990 Town and Country Planning Act.
So that goes back to the point that I was raising with you. We see from section 1.5 of the Listed Buildings Act that sometimes what matters is whether something is a building or part of building. And sometimes it matters whether it forms part of the land. And we have the definition of building on page 393, which is not put in terms of the basic common law distinction between land and chattels, but has its own definition of building. So when you, in your opening comments, seemed to suggest that it was, if the inspector found that things were chattels, they could not be part of the buildings. Just so you know, I question whether that necessarily follows, because the notion of chattels being something different from land is understood in the common law, but that's not the concept we're concerned with. We're concerned with buildings or not buildings. Is that correct?
Yes, and the question as to whether or not something is a building in this legislation, I'll take my lord more to due course.
Yes.
Is the property law test, and that's the Cawthorne case and the way in which that's explained.
All right.
By Lord Mackay.
I mean, I think there'll be a question about to what extent the context otherwise
Yes.
requires in the listed building section. I think it's a difficult question which I want to be assisted on, because whether the sort of planning cases about cranes and things like that really can be transferred to the listed building context is, I think, something we'll want to look at.
My lord, I appreciate that. But to preface that, our view is that the planning cases are not the right approach. It's a property approach which is the right approach. Although we do make the point in practice, and it would be the same case in this case, the same result is likely to be reached as to whether or not something was a building. That's everything I want to say at the moment on section 1. Obviously, we'll come to some of the issues within that in due course. Section 2 of the Listed Building Act deals with the post decision procedure. That's page 272 electronically. So the list has to be sent to, an amendments list sent to the local authority. Section 2.2, that's to be a local land charge. And section 2.3, the Secretary of State informs the local authority, and the authority are then required in section 3, so it's 2.3b, to give notice to the owner and occupier. There's no mechanism for review or appeal in those processes. A process has been brought in Wales, and that's section 2a to 2d. If an item, if there is a listed building, then the principal restriction arises in section 9, which the court will find at page 280.
Are we leaving 2D then? You've mentioned the Welsh provision. I do have a question on that, if you're prepared to go back.
So certainly, my lord.
275, 276. The Welsh provision provides for an application for review by the Welsh ministers. And subsection 6, the Welsh ministers must, by regulations, make provision about the grounds on which an application for review under this section may be made. I couldn't immediately lay my hands in on the regulations in the authorities.
I apologise, my lord, that they're not. They're not there. I can give the reference. The regulations are the listed buildings. Open bracket.
Would it be possible to have a
I'm sure
copy
we
of,
can do that.
It's really only the grounds for an application. You can tell us, but I'd like to see it in black and white.
Absolutely.
Is one of the grounds this isn't a building?
It isn't, my lord. It's the regulations. I'll give the court reference and we'll get a copy as soon as we can.
Well, thank you.
The list of buildings review of listing decisions, Wales Regulations 2017. And by Regulation 4, the only ground of review is that the building is not of special interest.
Oh, I see.
So
So perhaps it matters very much further.
so it wouldn't
I mean,
actually
was
result.
that the first regulations in 2017? I suspect it probably was.
Yes.
And it probably did it come after the decision in Sir Justice Singh's decision in this case.
I suspect it came first. Somebody will
Anyway, never mind.
somebody will check. But
I think we would like a copy of the regulations, such as identify the grounds, even though you've told us
Yes.
what they say.
no.
Thank you. Now, where do we go?
We'll do that.
next?
Section 7, my lord, which is at page 280. So, subject to the following provisions, this Act, no person shall execute or cause to be executed any works for the demolition of a listed building or for its alteration or extension in any manner which would affect its character as a building of special architectural or historic interest unless the works are authorised. So that's the prohibition on works of certain character. One of those works is demolition. Illustrates that we are talking here about buildings rather than talking about objects or items that can be destroyed. But that's the prohibition in section 7.
Is it alleged that you've demolished this vase?
Yes, it's the
Yeah, so they did, but don't worry now.
it is, but that's how it's put. And of course, if it's a building, then taking it down, even if you're then going to re-erect it elsewhere, one can understand that demolition covers that, although not terribly comfortably. But demolition is an appropriate expression to use for objects. It's one of the numerous indicators in this legislation that we are dealing with buildings. We're dealing with something which is fixed to the ground, which is part of the land, and that is what this process is about. It's not about protecting objects which are capable in some respect of being moved. So section 7 is the prohibition without authorization. Consent regime starts off with section 8, but then section 9 are the offences. So if a person contravenes 9.1 and 282, person contravenes section 7, he shall be guilty of an offence. That then feeds into not only it's an immediate criminal offence to
And that's a strict liability offence.
it's strict liability, my lord. The no question of knowledge is required. The only defence is an urgent works defence, which is in section 9.3. And it's an offence that's punishable by not only a fine but imprisonment for up to 2 years. The section 9 offence, we're just sort of stepping through the legislation, feeds into the enforced list of building enforcement notice procedure. So if the court goes please to MS page 301, which is the power to issue a list of building enforcement notice in section 38. And section 38, one word appears to the authority, the works have been or are being executed, the works such as involve a contravention of section 9.1. So that's the offence from contravening section 7, which takes us back to demolition of a listed building. Then the authority may serve an enforcement notice that would require steps to be taken, and those are set out in section 38 2, including restoring the building. Person having an interest in the building has a right of appeal. That's section 39, which is at page 303. This is the building is not of section 39(1). A is one of raising that it's not of special interest. C, that, well, B, just taken in sequence. B, the matters alleged to constitute a contravention of section 9(1) have not occurred. So the question of fact. And C, that those matters, if they occurred, do not constitute such a contravention. My Lord Conway will recall dealing with how those provisions are separated out in the planning enforcement regime in the
Well, I don't
United.
recall, and I was trying to remember. Can you remind me? I mean,
Uh,
what were they? They were to deal with a particular problem. I can't remember what it was.
It was this is in relation to my Lord's report in
Within my report.
1989. That's the particular issue at that stage was that on the conventional planning approach, what is now B and C were rather sort of merged
Yes.
together from recollection. I can
What I recommended they should be.
be separated to distinguish between ideally the factual situation,
Yes.
what happened, which is B,
And whether
and
the facts amount.
and is it a contravention, which is C.
Yeah.
And what we say, quite simply, in respect to the list of building enforcement, is that underground C, the matters do not constitute such a contravention, so a contravention of section 9, if what is the subject matter is not actually a listed building. There's no contravention.
As you put it on C, I would have thought you'd be better to put it on A, the building. There's got to be a building. And then the question is it not of special architectural or historic interest? I'm not quite sure what C adds to A for the purposes of your argument, Mr. Harwood.
A is focused on whether it is of special interest. So
Well,
essentially remake.
The first thing is it's got to be a building, I would have thought.
Yeah.
But you could read purposefully, certainly you could read 1A as reading, that the building is not a building of special architectural interest, which would be the most logical. I mean, that would expand.
I say my
what you
Lord's.
do is implicit anyway.
Yeah, my Lord's point that A could be read as encompassing potentially two elements. Is it a building? And secondly, is it
Well,
of
right.
special interest?
Yes.
But you don't mind whether it's an A or C, presumably.
Well, my Lord's and my lady, as far as we're concerned, the key thing is that the issue is one which is dealt with, and we say it can be raised, and we raised it very, very firmly. And we say in terms of C, it's not a contravention of 9(1). If it's not a contravention of section 7, it needs to be a listed building. It's not a listed building even if it is under section 1.5, if it's on the list, but it's not a building, it's not a listed building within the definition. And that simply as a matter of statutory language gets us within the ability of the appeal system to consider the issue.
Yeah.
Now, the other way in which the appeal mechanisms are accepted as enabling, we say, these issues to be addressed is that it can be considered on appeal whether or not listed building consent is required. And I've taken my lords to the listed building enforcement notice provisions, but there's also, as the court will anticipate, a right of appeal in respect of a listed building consent application. And that is at page 290, section 20. So that's the right to appeal against the refusal of listed building consent application, or a failure to determine, or a condition that's imposed on that. In dealing with listed building consent application, it is permissible to consider whether or not listed building consent is actually required. And that's been dealt with in two authorities I want to take the court to. First of all, the decision of the House of Lords in City of Edinburgh, which starts at page 588 of volume 1 of the authorities. And that concerned, amongst other things, whether or not particular buildings were covered by the listing. So a question of interpreting the list description. But the point is made by Lord Clyde at page 596 of the bundle, page 1455D of the report, that the reporters, that's the Scottish inspector, considered a preliminary question whether listed building consent was required for the demolition of the former riding school building. Not been suggested that he was not entitled to explore that question, and I expressed no view on the propriety of him doing so. But it's been taken that that can be done, and that issue was considered further in the case of Chambers and Guildford.
Do we know on what basis it was said the listed building consent was not required?
It was on the interpretation of the list description to decide whether particular buildings had been covered, because the list description referred to, and the court will find it possibly conveniently enough in the head note, refers to Redford Barracks, original buildings of, this is at page 588, 1447 F, original buildings of 1909, 1915 only, and some of the buildings had been constructed just after that period. And the interpretation question was whether or not they were covered by that description.
So it's rather like the factual question I was putting to you about 1948, pre or post.
Yes, these cases illustrate that there are actually quite a few uncertainties which do arise as to whether something is covered by the listed building regime. That's another aspect of that here. So, as was said in City of Edinburgh, in the Chambers and Guildford Borough Council case, which is in volume 2 of the authorities, starts at page 746. The issue in that case was whether a Second World War pillbox, which had been constructed a few meters away from a farmhouse, the farmhouse subsequently being listed, was a curtilage listed structure, so within section 15B. The particular issue arose, whilst it was very close, certainly within the curtilage, the decision of the House of Lords in Debenhams is that the curtilage listed needs to be ancillary to the listed building. And the proceedings have been brought in Chambers to seek a declaration from the court about that. The council responded to say, well, that's a matter which actually can be dealt with and is best dealt with on a listed building consent application being made. The council can express a view whether it's curtilage listed or not, and if necessary, on appeal. So the inspector could consider whether or not this pillbox was part of the listed building in the appeal process. That was the council's argument, and that was accepted by Mr. Justice McComb. And may be helpful in due course for the court to look at from paragraph 19 onwards. He cites City of Edinburgh and then to resolve it. But paragraph 27, which is page 755, Mr. Justice McComb set out sort of Mr. Minor's issues, a number of issues, including is the building in question a building included in the list, and then particularly pertinent in that case is paragraph 27, paragraph 3 is included in a list by virtue of section 1. Within a list of building by virtue of section 1.5, and Mr. Justice McComb. So the only issues 2 and 3 for consideration seems to issue one of juridically similar nature. Raised the question whether the listing includes the structure in issue.
Sorry, where are you reading that?
I'm sorry, paragraph 27.
Yes.
My Lord, under the numbered points, we have the paragraph at the bottom of those issues.
Yes, thank you.
Yeah. It seems to me it can hardly be intended by Parliament the planning authority or inspector would be precluded from simply finding that the structure in question was simply not part of the listed description at all. That's the sentence of the City of Edinburgh. Point, extraordinary or Parliament envisaged dispute of the present kind should be decided in High Court proceedings. So the view which the court took there was that the question of whether or not listed building consent was required, including whether or not what is subject to what is the listed building, is a matter which is eminently suited and can be dealt with in the planning application and appeal process.
Just seems rather counterintuitive to be raising the question of whether or not consent is required in an application for consent or an appeal from refusal to give consent.
I appreciate the question being counterintuitive. One would normally think, well, is there another mechanism for resolving that question? In general, there isn't. There is now a mechanism for a certificate as to whether proposed works to list a building are lawful, simply considering the question whether or not those works would affect special interest. And that's been introduced since the Chamber's decision. But the broader questions as to whether or not listed building consent is required or whether you in fact already have listed building consent are not ones which are actually subject to a certificate process. And my Lord may be aware that in questions of do you need planning permission or do you have planning permission for particular works you're proposing, there is a separate certificate process in the Town and Country Planning Act 1990, sections 191, sections 192, which do that. But the listed building regime has not had a separate certification process for resolving these issues. It's now got a relatively limited process which is available. But of course, even if you do have that certification process, there are preliminary questions which can arise, one of which, and the authorities do establish it, which is if you are seeking listed building consent, do you need listed building consent in the first place? That might in some cases simply go over the head of the planning authority and they deal with the application. But if somebody raises that, particularly on appeal with an inspector, maybe it will be issue 1, do we actually need the consent? If not, the inspector then doesn't actually need to go on and determine whether or not consent's granted.
But is it right that, I mean, this decision, Lord Justice McComb in the present case seems to have had some doubts about what he said then, but as far as you know, people need to know what the right thing to do is. As far as you know, have people proceeded on the basis of McComb, of Chambers, treating that as being a way of finding out whether you need consent at all?
Yes, they have, my Lord. Usually there's a question, particularly when it comes to whether works of art, paintings and sculptures are part of a listed building or not. The issue does arise in quite a few contexts. Often the effort will be to resolve that informally, to get a letter from the local authority or Historic England saying, no, this painting isn't, you can remove it. But if you're looking at a way of resolving it, the way would be by an application. And in the Chamber's case, the court having said you should go to the planning inspectorate on this, the inspector then subsequently did conclude that the pillbox wasn't ancillary to the farmhouse
No.
and so wasn't subject to the listed control. And presumably that's now been cleared away to.
So that practice seems to be,
Yes, my
as you
lord.
know, well established.
Yes, my lord. Because it becomes a way of getting a determination and getting a determination in a very open process. So the nature, I'll pick at this point a little more in due course, the nature of the planning appeal process and the listed building appeal process is all very much part of that, is it's a very public process. There's a document, an application to local authority or an enforcement notice, which is going to be available. That material is generally put on websites and representation put on websites. Anyone who is interested may make representations and may well appear at a subsequent hearing or inquiry. It's a very public, open process with procedures in place to ensure that it's carried out in a fair manner.
Sorry, could I just make sure I understand you? So if one makes an application for listed building consent under section 10, one could, in the context of that application, as I understand your submission, say, well, we don't need consent for, among other reasons, this is not a building.
Yes, my lord.
Is that the way it would work?
Yes, and what ordinarily you somebody would do in that situation would be to make the application saying, first of all, we don't need consent, and we'd like you, the local authority, to say we don't need consent and sort of return the application to us. But of course, usually then the second string is if you think we do need consent, to grant us the consent. And then if consent is not granted or it's not resolved one way or another satisfactory at the local authority level, then on appeal, the appellant may well say, first of all, Secretary of State, please say we don't need consent, for example, to remove this chandelier from the chapel. And if you do think we do need consent for it because you think the chandelier is part of the building, then please do grant us listed building consent.
And would one at the same time say, and if we don't need it because it's not a building, please amend the list under section 1.1?
Yes, on by means of an appeal.
By means of the appeal.
What one would, well, there was two ways of proceeding in terms of seeking a change to what's on the list. One, which is where you have the right to raise the point, is by means of an appeal. Either an appeal on a listed building consent application or an appeal on a listed building enforcement notice, because on those appeals, the Secretary of State has the power to remove the building from the list. And also, as a preliminary point, of course, if it's not a building, whatever it is, whether it's is it a curtilage structure, what does the description in the list mean?
I see.
Is it in...
Sorry to cut you short.
No.
But am I understanding you correctly that one has to, before one can invoke section 1.1, one has to take it up on appeal?
In terms of seeking change, there are two...
Changed the list. You said, I don't need consent, but if I do need it, please give it to me. And the reason I don't need it is because it's not a building, and so please amend the list accordingly.
Yes, in terms of saying you don't need the consent, you'd start that with an application to the local authority,
Yes.
then if need be on appeal. In terms of changing the list in that process and removing something from this in the situation we have of it not being a building, would be a consequence on a determination that it's not a building and so consent's not required. It's the next stage that follows on to tidy up the list. The two mechanisms for doing that are either to raise the point on appeal, and the power is given to the Secretary of State on the appeal, and it's then given to the inspector to amend the list to remove the building, to remove the building from the list.
So just on that, is there some specific provision that says where there's an appeal, one of the consequences can be an amendment to the list?
Yes, my lord. And I'll just pick up.
Well, don't take up time on it now,
No,
but if someone could give us that reference.
Could it be section
Yes.
41(6)(c), Mr. Harwood,
Yes, in respect of a listed building enforcement notice.
at 306?
And in respect of a thank you, of an application for listed building consent by section 21(3), a person can raise the argument it's not a special interest. Of course, there's one reason for removing from the list, but only one reason. But it can be removed from the list by section 22(1)(b), gives a power to the Secretary of State to remove from the list. The inspector, or an inspector is dealing with an appeal, has the same powers of as the Secretary of State, and that is in the Listed Building Act, Schedule 3, paragraph 2(1), for the note that's page 324. So a point which was made incorrectly by Mr. Justice Singh, that the power to remove from the list is given to the inspector, but not to the to the Secretary of State, but not to the inspector, is incorrect there. That and all listed building consents and listed building force notice appeals are in the jargon transferred to inspectors. So ordinarily they will be determined by inspectors. The Secretary of State may recover jurisdiction, take back the power to determine it from the inspector in a particular case if he chooses to do so. But it is a feature of the process that if the Secretary of State thinks that something is a listed, something is a special interest or is a listed building, that the Secretary of State can be overruled by an inspector. That is what Parliament has prescribed.
But I mean, it must be open to the Secretary of State to amend the list himself without going through that process.
Yeah. And
Well, section 1 gives them a general power to amend at any time.
absolutely, my lords. It's section 1(1) gives the power to do that. I drew attention to the last few words, may amend the list, but it's important to have in mind that that choosing to amend the list is discretionary. And it's discretionary as to whether or not the Secretary of State entertains a request. And the Secretary of State's approach has been actually quite restrictive in terms of entertaining requests of looking for, say, significant new information and so on. So there's no assurance that if you do ask the Secretary of State will actually look into that. Whereas on an appeal, of course, the appellant is entitled to take any points which are within the ambit of the appeal and which he wishes to do so, and then they will have to be dealt with. The Secretary of State's policies, we've picked up already in the local authority correspondence, is that where enforcement proceedings are a possibility, the Secretary of State will not consider requests for delisting, the rationale being that that is something which will then be addressed, if it needs to be, on an appeal, a listed building enforcement notice appeal.
Just sorry to bottom this out. So under section 22(1)(b), it's your submission that it would be entirely appropriate for the Secretary of State on an appeal to amend the list by taking a structure off it on the basis that it's not a building within the meaning of the legislation.
Yes, my lord.
Thank you.
Now, I've taken the court largely through the legislation. I want to pick up before I move to sort of the general principle of ability to challenge, on what is the approach to building in and the need to consider it, which is the Cawthorne case. So if we turn up in volume 1 of the authorities, tab 11, it's page 417. Decision of Lord Justice Russell, and that concerned what were then building preservation orders. And that was an order which the local authority would make in respect to a building they thought of a special interest, requiring the confirmation of the minister. And the effect of the order would be that consent would then be required for the works which were specified within the order. In that case, the issue which was raised was whether or not items which had been listed in the order, which included portrait panels, large wood carvings, this is neatly enough in the head note 417, was wood carvings and wooden equestrian figures, whether they were part of the building. The first point to make to the court is that the Secretary of State, in confirming the order, needed to consider whether what the local authority had identified as being the building was within the building, these particular items. And then secondly, because we have this to hand, the court then considering what the test was. Now, the definition of building at that time was not the expanded definition with the A and B in terms of fixed or curtilage structures, which we now find in the legislation, but section 30 of the Town and Country Planning Act 1962 referred simply to buildings, and we find it is set out at 418 in the report, but also we do find section 30 itself at page 342, so simply to buildings. And the definition of building which applied in the 1962 Act, we find at page 350 in section 221, building includes any structure, 221, page 350, middle of that page, building includes any structural erection and any part of a building, so same as the definition which is currently.
So that was just the ordinary planning definition, which was then
yeah,
applied to the building preservation provisions which were part of the same act.
Correct, my lord. And what the definition did not have was the A and B it subsequently has in terms of fixtures. So Lord Justice Russell was asking himself the question as to whether the building included these portrait panels and wooden figures. And the approach which he took, and we see this at page 420, page 213 of the report, tells the middle at the end of the first paragraph. As far as all the items could properly be described as fixtures, as that phrase is commonly applied in law, and drew attention to drawn to the cases on ornamental fixtures.
What's the point you're collecting from the Cawthorne case?
Two points, my lord. One is, in respect of issue 1, the ability of the minister in that particular context to consider whether or not what the authority had said was a building was a building. So the minister's jurisdiction in that case came to that.
Sorry, I thought that there's no doubt that Scarisbrooke House is a building.
Absolutely, my lord. The issue
The
is
question is whether these items were part of that building.
yes, and so within the definition of building encompassed
Right.
those items. The second point, which relates to issue 2 from Cawthorne, is that in deciding what was a building, in that case including those particular elements, the approach which the court took was to apply the property law test, the purpose and degree
But
of
that's just to
annexation.
see whether they're part of the building. In our case, the issue is whether the items were a building or not.
Yes, I mean, it seems to me that this case is fairly marginal, but I mean, you can rely on it. It was clearly thought that property concepts were relevant to the definition of building in the Planning Act. And secondly, at least if current law statutes are right, it was this that prompted the amendment of the definition in the 1968 Act, which brought in the specific reference to objects and structures. I mean, that I would have thought is the only interest of this building. But, I mean, it's a very interesting judgment, but there's not much else you get from it.
Well, my lord, what it does is in terms of looking as to whether something is a building, and of course that point arises both the question what's comprised within something which is a building.
Yes, so
Which
my
is a
point
particular
is
case.
Scarisbrooke House undoubtedly a building.
Indeed.
Question is whether these panels are part of that building,
My lord.
and the court adopts, in answering that question, the landlord tests. Are they screwed into the walls and a fixture?
And in a situation where you move outside into the garden to decide whether something is part of the land law tests are in land law the same tests apply the purpose and degree of annexation.
Yes, but that rather makes the point that I've put to you now more than once, that for the purposes of the question we're concerned with, it's clear that in certain contexts the statute uses a land law test. We've seen that from section 1.5 itself in the extended definition of building. We see it comes in Cawthorne when you're looking to see whether something is part of which is listed. But we're dealing with a distinct question, whether a structure is a building itself. And on that, the relevant test is whether it falls within the definition of building, which is not put in terms of the traditional land law test of land as against chattels. It's got its own
It'd be a
text.
bit odd if you have the property test coming in most of the way, and then you decide whether, I mean, if an object is being brought in simply because it's part of a Scarisbrooke house, it's a nice statue in the garden. The question is whether it's attached to the land. If it isn't, then it's not within the listing. It's slightly odd if there's a sort of separate thing, completely different test to decide whether a building like ours or a structure, an urn like ours is a building. I mean, I'm finding this sort of dichotomy slightly tricky.
Right. Well, at the moment, it just seems to me that's the way the legislation works. My lord might be right that one interprets the definition of building in a particular way, but anyway, I've just expressed the point for myself. There seems to be a clear contrast in the text of the legislation between the extended part of section 1.5, which clearly does talk about items forming part of the land, and the test of building, which doesn't use that language at any rate.
And my lord, the way in which there is that degree of bridge, which is the assistance which the court does get from Cawthorne, is that Cawthorne was dealing with building without that extended language of A and B, which, as my lord recognises, is accepted as being the property law test. So we're still looking at the question of a building. And to pick up my lord Lord Carnwath's point of a dichotomy, that there is no good reason why a different approach applies in the first line of 1.5 building, the word building is used, and then later on in 1.5 and to create this situation that let's assume that the piers and the urns had been in place before 1948. We went to the 1948 issue, so they've been in place earlier. They're not referred to in the listing of the house. They're not separately listed in their own right. On that assumption, the question which would have arisen as to whether or not they were part of the listed building of the house would have been the section 15B question, which, as my lord said, is answered by using property law principles. Whether or not they could be listed in their own right as buildings is just a question which also involves the same considerations of the property law questions of purpose and degree of annexation. Now, whether there's a distinction between, if it said they're objects but they're not structures, that may be a further reason for them not being buildings. But it's just that the proper interpretation of 1.5 is that the understanding of the concepts is done by the same mechanism, which is the property law tests.
Well, I thought section 1.5 you've shown us takes us back to section 336 in the main statute. So when you're asking whether something is a building, aren't you applying that statutory test, which is not put in landlord terms? It has its own language. I mean, I follow that one might say, well, that language it comes very close to importing landlord tests, and therefore one ought to treat it as in some way informed by a landlord test. But anyway, speaking for myself, it seems to me clearly different from a landlord test, and advisedly so, because we see when the statute wants to talk about something forming part of the land, it uses that very concept.
Well, I don't want to go back over, back around, but my lord has the way it's addressed in Cawthorne. But the essence of listing in those circumstances is the nature of dealing with items which are part of the land. They're fixed, whether that's something which is whether you're particularly concerned with the object itself as being fixed, as being the building, or debating the question of whether something is part of the building. It's that nature of a protective regime for buildings, for things which are of interest and protected because of where they are, and it stops you moving them. And so that sense of attachment to the land in a way which doesn't admit ordinarily of movement is one which is integral to the question of listed building control. It's not simply a protective mechanism for objects of historical, cultural interest in their own right.
So a summer house would not be a building if it was simply capable of being lifted and moved somewhere else?
It would depend on, there are two ways of looking at it. In terms of the property law approach, the purpose and degree of an annexation. So prima facie, something simply resting on the ground is not part of the land. So it's not a building. In context of some house, you may how far it is fixed in place. And again, one aspect of that is that if you can remove it pretty much in one piece, and then simply put it somewhere else, it is not likely to be built. If you have to completely dismantle it, to take it down or to sort of demolish it to move it, then even if it's simply resting, it is likely more likely therefore to be a building.
But I thought that barn case, I'm sorry, it's now escaped my, the name has escaped me, where people demolished the barn, so it was simply a heap of planks, was nonetheless within the listed buildings legislation.
Yes, lady, that's the Leinster case that's referred to in the
It's just-
Judge and First Secretary of State decision. And there what there was a barn, which was a listed building. There was no dispute it was a building. That was dismantled with 70–80%, I think, of the bits being capable of reuse, the intention being to ship it over to the United States of America and re-erect in some form. And so what there was on that case was something which was a building, and no dispute on that. The purpose of the listed building regime was achieved by keeping the listed building protection. So those dismantled parts were still subject to listed building control, and so could be subject to enforcement notice and injunction to get them back.
I
And
mean,
so,
that's a good example of how you need to apply a bit of common sense
indeed,
and not be too hidebound by the literal wording of the section.
indeed, Michael, because it's a very different. It's a very different point, and one of the errors which the inspector fell into, he referred to the Judge case, which involved a statue and the various piers and brickwork around it, which was listed, being then moved on listed building consent across the square. And the inspector said, well, in that case, listed building control still applied to the statue and the various parts of it, whilst they were removed and then to be re-erected. That's fine. To say that something which was a building is then dismantled, listed building control applies to that, makes perfect sense. It's a very different situation to whether something which isn't a building in the first place, which does remain simply as chattels, whether that is encompassed by a building. And just to sort of find my lady's point, a summer house may well be a building. Depends question of the size, and say from some garden sheds might not count, quite often they would.
Sorry, so are you saying a summer house could be a building even though it might not be affixed to the land?
If you have to, if you have to dismantle it in terms of,
But it has to be part of the land unless it's, if you're bringing it within the extended definition. Unless you're saying it's a sort of
Well, speaking for myself, I'm not sure that I would accept that, but I was interested in the answer you were just giving, because looking at the definition in section 336, building includes any structure or erection. And you seem to be making the point that, yes, my lady may be right, that the summer house not fixed to the land can be a building, but that there's a test of sort of, it's something that needs to be constructed or dismantled if you want to move it, that gives the test. Did I understand you correctly?
that. Sort of like that comes into two different aspects of the question. One is in terms of the property law tests that.
I'm just looking at the test in section 336.
I mean, clearly a summer house can be a building. If
Absolutely,
it's built. I mean, obviously they're difficult questions if it's just something you plug there.
Yeah.
Those are issues which would have to be sorted out on the facts. But if you're trying to bring it in under the extended definition, then clearly it has to be part of the land because that's what it says. But I mean, we're miles away from a vase, which is what we're talking about in this case, I'm afraid.
Forgive me. I mean,
I'm sorry,
I wasn't seeking to speak about the extended definition. I was just looking at the definition of building in section 336. And I did want to understand your submission about my lady's summer house example. So summer house, not affixed to the ground other than by its own weight, but something that in order to move, you have to take apart and dismantle.
Yeah.
And then if you want to move it, you have to put it together again somewhere else.
Yes, and that's.
So the question is that a
that
building?
meets, if I make my law, sort of two potential aspects. One is fits neatly into sort of the property law approach. Holland and Hodgson, where Lord Blackburn gives the example of a dry stone wall. That starts off as stone. You put it together, then what you do have something that is part of the land. And also, if one was looking, 336 usually is in the context, the purely planning context, what I refer to as the Skerritts approach, then putting a summer house together may well be a building operation if you have to assemble it and then dismantle it in due course. My Lord, those are well away from. Can I, if I may, my lords, I've covered quite a few of the later issues.
I was
as well,
going
which
to
is
talk to
helpful.
you about timing.
Yes,
You've got 33 minutes left. I think you've got quite a long way to go.
yes, my lord.
So have that in mind.
I do thank you, my lord. What I want to do, I've dealt with the working of the scheme. I then want to pick up on what was my second point, which is the principle of an opportunity to challenge as a general approach. And what we say is there's a strong presumption that an individual is permitted to challenge the validity of an administrative decision, particularly in defence of an action against them by the state, subject, of course, to what the statute provides. And that principle, which seems to us to be essentially not in dispute, is one which is set very clearly by the House of Lords in Boddington, which, for the note, is tab 23, page 664, and most usefully in that context at 671 from the speech of Lord Irvine, pages 153, 154 of the report. Apologise that the online version is perhaps not the most user-friendly. We do have another, the PDF.
That did cross my mind, but there isn't time to make an elaborate complaint about it.
We have the PDF if the court would like to have that.
We're working from these.
Which page would you like us to go to?
Page 167 of the.
Well, we haven't got that.
Sorry, I apologise. I've got to sign it. 6671. I simply transpose. And that in the context of the middle of the printout, which begins Lord Denning, just talking about the head case, the middle of that paragraph, Lord Irving is saying, it would be a fundamental departure from the rule of law if an individual were liable to conviction for contravention of some rule, which is itself liable to be set aside by a court as unlawful. Now, the general principles I will take, if I may, as read. It depends on the statute, and in cases such as Wicks, where the question was whether or not on a defence to enforcement note, planning enforcement notice prosecution, it was possible to raise grounds relating to the lawfulness of the enforcement notice. The court said in that context it's not, in part because most of the grounds of which you could challenge the enforcement notice, ones you have to take in the appeal, and the legislation provides that those grounds may not be raised in other circumstances. And the small element of residual grounds, the court took the view that the process required those to be dealt with, in that case necessarily by judicial review, long before a prosecution arose. But looking at the factors in this case, and we set those out at paragraph 55 of our written case, which is page 82, whether the administrative act is specifically addressed to an individual. In this case, it obviously affects the world at large, although it does, we acknowledge something which individuals should have notification of. whether a specific right of statutory appeal or of a statutory remedy available to challenge the administrative act in question, we say, well, there is, but it's the mechanisms which we are using.
Well, I mean, a big question here is whether judicial review of a listing is enough, and that you're asking for unnecessary muscularity in our analysis of the act by asking us to rule that on an appeal, the inspector can ask himself, is it a building? So what do you say about why judicial review of the listing isn't good enough?
Judicial review is very much a matter of last resort. It is a process which could seek to avoid to have to take. So it does involve looking at what the mechanisms are within the regime. It's not the most obviously suited process to dealing with the issues which we have here, because this issue, whether something is a building, is a matter which will involve factual findings, which may or may not take some effort to reach, would benefit from a site visit. Again, a matter that's not normally addressed in judicial review. As Mr. Justice McComb said in Chambers and Guildford, the issues of, in that case, whether that was covered, the pillbox as part of the listed building, are issues which fall very naturally to be dealt with through the planning process.
And he went further, he said it was wholly unsuitable for the court proceeding.
Yes. A court may sometimes have to deal with those, but it's not not the ideal mechanism. What our appeal mechanism does is to enable the decision maker, the Secretary of State or the inspector, to go to the heart of the issues of whether something is a building. In the judicial review context, any debate is going to be a little bit rather wrapped up by what is it that's being challenged. The only decision we have here of the Secretary of State which bears on whether it's a building is the decision to list in 1986. By the time that entry was put on the local land charges register in January 1987, any judicial review proceedings would have been 3 months out of time.
Yes, but
An extension of time would have been required at that point. By the time the whole issue is raised with Mr. Dill in 2015, an extension of time of somewhere over 28 years would have been required, which might be a record.
Yeah, I mean, there's no reason why you shouldn't be able to do that. If you bona fide haven't heard about it, then why not get review? But I mean, surely the problem is much more the question, these are factual judgments, legal and factual judgments.
Indeed, my lord.
And also ones on which the inspectors can develop some sort of practice as how they deal with them on a regular basis, because the court can't do that.
Yes.
Whereas we see the sort of guidance given by historic England, which doesn't actually deal with this, but could well deal with when you regard something like a garden urn as a structure in its own right.
And my lord, and it's eminently suited to that process. The fact that judicial review, I have a final point on judicial review in terms of challenging the 86 decision, no one has actually the file for what the Secretary of State had considered. It becomes a very difficult challenge for all concerned to know what the minister had in mind. But the fact that it is maybe possible to bring judicial review proceedings does not mean that that is the only recourse, or the government defaults towards saying that it actually quite likes judicial review proceedings, rather than a mechanism where the legislation provides for it or enables that to be done, of the Secretary of State or an inspector getting to grips with the real issue.
What's the appeal route from the inspector?
To challenge the inspector's decision, it is by inspector listed building consent, an application to the High Court under Section 63 of the Listed Building Act, and in respect to the Listed Building Enforcement Notice, it's an appeal to the High Court under Section 65. And because both matters were being appealed, we've gone down both routes in this case.
So if he'd come to a view about whether it was a building, would it have formed part of that application by way of appeal?
Yes, we,
It'd be an adverse to you.
A legal issue could, not the
Yeah.
factual issue.
yes, my lord. The ground of appeal is the enforcement is limited to points of law, and as my lords
So,
said, it becomes a review.
so you've still got the problem that it becomes a point of law at that stage.
Yes, but by that stage, one would have hoped the inspector would have made
The
factual findings, and if the inspector was then asked the correct legal questions, one hopefully would have the right answer. And if there's an issue as to whether or not the inspectors failed to ask the right question, for example, then the court will deal with it. The final matter I want to deal with on issue 1 is just to draw the court's attention to the well-established case law. The references are in there. I won't give where on enforcement notice appeal or on a later planning application and appeal, it is possible to consider, for example, in respect to consider the lawfulness of a condition which was imposed on an earlier planning permission. There's a decision of the House of Lords in Newbury where the point was accepted, and the Court of Appeal in Earthline where that issue was considered in detail as to whether or not it could be taken. The final point I want to deal with on issue 1 is that the other aspect of alternative routes is in terms of a request being made to the Secretary of State to delist. And I've dealt with the problems of whether or not that would be considered. There is just a degree of clarity in the Secretary of State's position as to what the scope of that exercise would be. We say, well, of course, the Secretary of State could say that something that's been put on the list is not a building and so should not be on the list, and that's the determination that becomes binding. But the fact that the Secretary of State could do that under Section 1, Secretary is also able to do that on an appeal. If he can do it in response to a letter, he can do it in response to an appeal.
But does that help you if an amendment is only prospective?
The preliminary, because the preliminary it helps with but the preliminary point, of course, is the decision as to whether or not something which has been on the list as a building, that would be in the situation, certainly in the situation we are in, a decision as to whether or not it was a building at all. So the minister would have reached a view that it, in those circumstances, it should never have been on the list, and then a consequence of that is then to amend the list to remove it.
But as my lord says, there'd still be a problem, wouldn't there? Because you'd have committed an offence contrary to Section 7 by demolishing something, if that's what you've done, which is on the list, if the amendment to the list is only prospective.
What we would have in that situation is if the Secretary of State had considered it simply as an informal request, then the Secretary of State would have reached a determination which would have been sort of relevant to a prosecution. If we have a determination on an appeal, then that decision, subject to appeals to the applications to the High Court, is a determinative, Section 63 and Section 62 and Section 64. So those will be binding in future decisions. A criminal court will not be able to go back behind the enforcement notice decision. If it came to it, of course, where there was a prosecution being brought, the prosecution would have to show that it was a listed building which had been demolished. And so if need be, the court would have to then deal with the question of whether or not what was on there was a building.
So in the context of a prosecution, you say the question whether or not it was ever a building is is a permissible one to raise, and if it isn't a building, would be a defence, even though that structure was listed at the relevant time.
Yes, on the Section 9 offence, it would be, because it was not a listed building. And similar issues would arise were Mr. and Mrs. Chambers to demolish the pillbox without resolving that issue, whether it was curtilage listed. In terms, though, of the listed building enforcement notice, was the prosecution for failure to comply with that. The listed building enforcement notice is treated as being valid, and that's Section 64 and the effect of Wicks. So from Mr. Dill's perspective, in terms of the listed building enforcement notice, his only way of raising the issue as to whether or not this is a building is in the course of the appeal to the Secretary of State.
Surely it helps you that in relation to a criminal prosecution for an offence contrary to Section 7, I think it is, you can raise the question, well, is it a building at all, even though it's on the list? Because that shows that the list, at least for some purposes, is not definitive of the question whether it's a building.
Yes, my lord. Yes, we say that follows from all our analysis, that you must be able to raise that on the Section 9 prosecution.
Yes, thank you.
That was everything I intended to say at this stage on issue 1. If I can turn then to issue 2, and the 17 minutes or so I have, quite a lot of the points we've covered in the discussion. So I hope I can then take most of that relatively quickly, but I'm going to deal with 3 points within that. First of all, that the regime is concerned with protecting buildings, not objects. Secondly, the application of we say the correct test of it's the property law test, purpose and degree of annexation. Although as an alternative, it's the planning, what we refer to as the Skerritts test. And then just look at where that then leaves us with the inspector's acceptance of these items being chattels. First point, protecting buildings, not objects. The references to buildings, but also there are further references which point to it being something which is fixed and in place. So the assumption that the building has a curtilage being an area, a parcel of land which is associated with a building. We find that in section 1, subsection 3 and subsection 5. It, of course, the listing description relates to something within a council area, the notice to the council under section 2.1, and it being a local land charge. Demolition, I've mentioned, that's akin to a building rather than something that's movable. Listed buildings having a setting, we see that as being something to be protected as section 16 and section 66 of the Listed Building Act. But a setting is involves the notion of the building being in one place and how you experience it. Direct action, the ability of the authority to carry out works on a listed building entering the land, and section 43 is to enter the land. And the prosecution for failing to comply with a listed building enforcement notice is brought against the owner of the land under section 44. So that's all ties with land rather than something which is more movable. The approach of the Secretary of State for Culture, Media and Sport is in the principles of selection. That goes to the selections whether or not something should be listed. And the court will find that in the second authorities bundle, tab 39, page 921. And these are the current to 2018 principles. At page 921, paragraph 6 tells us that for the purposes of listing, a building incorporates any structure, referring of course to what's in section 1, subsection 5. It includes any object or structure Now, my learned friend, Mr. Elvin, seeks to pick us up by saying, well, the language is for A and B are treated as part of the building, and criticise our use of the word includes. The word includes is the language which the Secretary of State is content to use. In this context, they mean the same, this particular context. And then it goes on in paragraph 5, to tell us that in some cases, such as for works of art or sculptures, it will be necessary to consider the degree and purpose of annexation to the land or building to determine whether it may be listed under the 1990 Act. So it's the Secretary of State's view that we pick up the property law tests, and we do that as it's expressed there, not simply in terms of A and B, but also in terms of what the paragraph kicks off, the meaning of building, and it ends where it may be listed under the 1990 Act. So the Secretary of State has been applying the property law test, the whole of Section 1(5), and the Secretary of State has been right to do so.
Is there anything in this note which sort of treats works of art or sculptures as separate buildings in their own right, apart from the extended definition?
Not that I can think of on...
Paragraph 3, I'm being told.
Yeah.
Oh, I see.
Yeah, diverse range, the sculptures, the cinemas, and that's...
Yes, it's not clear whether that's treating them
Yeah.
as within the extended definition or under the main definition.
Yeah. And there's a reference to there's a further reference, once we have it, in the Historic England listing selection guide, which is sort of essentially the Historic England guide that sits below the principles, which is in tab 38. The particular one is garden and park structures, that's 894. And under specific considerations at page 906, there's a reference in the right-hand column to stannary urns and other features such as sundials and astronomical devices integral to formal gardens. And over the page 907, talking about survivals being fairly common, talk about pre-1850 examples generally meriting designation. Resident Park will strengthen the case. Of course, it is, that's why I think more commonly the case with statues and so on of interest, that they've been at the property for several centuries, might have moved possibly in time, but have been there for a long time. What is most remarkable about this case is the way in which the stannary, the urns had moved around and only reached Idlicott 13 years before they were listed.
Is that our rest park on the previous page, 902?
It is. I don't know whether the various statues we can see in the photograph of Rest Park are actually listed. Although I do note that the caption refers to the registered garden status, and beyond it, Thomas Archer's Pavilion, which is listed grade 1, and the court can see that in the far distance, and that's most obviously a building. But I don't know whether those two sculptures are listed in their own right in that case. Now, the Cawthorne decision was explained in Debenhams, and I'd like just to turn that up, which is volume 1 of the authorities, tab 17. And page 561 is the start of the report, and that was a question which arose in the rating context as to whether or not something was a listed building, and is primarily concerned with whether there's the need for structures to be ancillary within 1.5, again to a qualification on the plain language of the legislation. That's dealt with particularly by Lord Keefe at page 568 of the
568.
568, my lord.
Yeah.
The ancillary element, which going back to some of the comments which we've had, the need to look at the legislation in context, that a structure needs to be ancillary to come within, was now 1.5b. But the status of Cawthorne and how that works was dealt with by Lord Mackay in his speech, which is at 573 of the volume. Page 408, and Lord Mackay summarises Cawthorne at 573. And then he says, at the bottom of that page, against this background, it appears to me the word fixed is intended in 54.9 to the same connotation as law of fixtures was achieved by the latter part of 54.9. That's what's now A and B, where rule of common law should be applied. And he says that introduction of A and B was, as Lord Carlton suggested earlier, to put beyond question the matter was decided in the Cawthorne case. It's a natural interpretation of the provision. It's confirming that Cawthorne was applying to the unextended definition, the property law approach. Now, the use of the property law approach reflects the permanent nature of listing, that it is fixing something in position. The presumption is it will stay there. And by aligning the questions as to what is a building with the property law approach, there is less likely to be a conflict in ownership, that somebody finds an item which they have and which they perhaps own separately to the ownership of the building or ownership of the land, getting caught and having to stay there. It doesn't eliminate the issues entirely, but it reflects the says that the separate division as to what this bit of historic environment legislation is about. Deal then mentioned what we refer to as the Skerritts approach. I just want to briefly pick up that reference. So if we go please in volume 1 of the authorities, tab 25, page, so I said volume 1, I apologise, it's volume 2. So volume 2 of the authorities, tab 25. And that concerned whether planning permission was required for the seasonal erection of a very large marquee, some 8 months of the year, a 7-bay marquee in the grounds of a hotel. And the approach which was taken is a number of references, but I'll just simply pick up one reference at page 715, which is part of the judgment of Lord Justice Pill. And it's referring to a judgment of Mr. Justice Jenkins in Cardiff Rating. Matter of considering size, permanence, and this is so the second paragraph of 715. Jenkins J says a threefold test which could involve considering size, permanence, and degree of physical attachment in considering whether an item was a building.
And you endorse that? You You adopt that as part of your submission.
as an alternative. We say that there are two possibilities to what is a building. The one which we say is the correct approach is the property law test, purpose and degree of annexation. Alternatively, if it isn't that, it will be the approach which has been applied in planning cases, where the question was whether or not building operations have been carried out, answered in some circumstances by asking whether what you produced is a building. So there's an alternative, and neither of which, of course, the inspector applied in this case. And applying...
And can I just check, was Mr. Justice Jenkins there applying what is now the test in section 336?
He was... So rating...
I think
Case.
Justice Bridge adopted it in Barvis.
adopted in Barvis, which was a planning
planning.
case, and we have Barvis in the Barvis in the bundle.
So it is an authority on the test in section 336.
It is, and Skerritts was looking at that in the context of whether building operations were involved in the seasonal erection of these very large marquees. But again, that points to what is rear physical attachment, which of course there wasn't in this case. The piers were resting on slabs and the urns were resting on the piers. Size, which one can appreciate that a 7-bay marquee, or as in Barvis, a movable crane, but one which was 89 feet high, as very sizable compared with the urns which we're dealing with in this case.
In Skerritts, what it got is quite a good illustration of the difference between what the inspector would do and what the court would do. Because all what Justice Schumann is saying is that the inspector was titled to reach the factual conclusion that this was a building.
Yes,
Without
and-
necessarily saying what the court would have thought.
Yes, and drew that distinction. And in terms of permanence, of course, we have differences in different cases. But what is very unusual in the present case is that these items, the finials and the piers, were being treated, they're being taken around by the family from home to home. They were not in place for the particular hall. They weren't looking at property test part of the design of the garden. They were something which the family had treated as chattels and took with them from place to place. And in terms then of where either of those approaches go, obviously, of course, the court would have to, if the court is with us that the issue should have been addressed, the court would have to quash or remit the decisions. But what we have are items which would seem not to be buildings. The inspector accepted they were chattels, and the distinction between chattels and fixtures or part of the land is well established in the property law sense. First two authorities, Holland and Hodgson, just give the note page 411, and then the House of Lords in Elitestone and Morris at page 611 of the authorities. But however far the court may wish to go, at the very least, there's a very real issue as to whether or not these items were buildings, and so whether they could have been put on the list. That's an issue which Marcus Dill has been seeking to raise now for almost 5 years since the problem first landed unexpectedly and very unwelcomely on his doorstep. It's an issue which the inspector on appeal is very well placed to deal with, and which the legislative regime allows the inspector to deal with. It's an issue which has not been dealt with.
But I mean, might it not be said that we've got a good view of the position one way or the other? We've got the photos of what they look like in situ and so on. So if we were able to make a decision as to what the relevant test was, are we not in a position to apply it ourselves?
Well, the court could say, the court's powers, of course, are to quash and to remit, but the court can make clear what it thinks the decision ought to be, as far as it is.
Are you inviting us to do that? Or it goes one way.
If the court is satisfied that these could not be buildings. I appreciate taking it one way, but one would expect to do that. And the court, without having to go beyond the facts, which
And it'd be unusual for us to do that at this level, I suspect.
But if the court is wishing to, is willing to push as far as we would like to push, then of course we wish the court to do so.
Mr. Harwood, thank
my
you
lord.
very much indeed.
My lord, I'm obliged.
Miss Dobson, are you going to follow? Very well. Mr. Elvin.
Please, my lady, lords, can I just pick up the last point just before I forget the answer to it? In relation to the question of judgment as to whether this was a building or not, the one thing the court does have is a very clear exposition by the inspector, who made it clear that there was limited information available, and he sets out what information there is. And you have that in the core bundle at pages 198 to 200. He deals with this under the ground C and ground A appeals, and he sets out very fully why he considered that the relevant tests weren't met so far as he interpreted the grounds of appeal. And you see, for example, at 39 and 40. But he does remind himself, and the point that I will come to in due course, is the definition of building at paragraph 24 includes any structure or erection.
Sorry, what are you looking at? 39 and 40?
I was drawing the court's attention, my lord, to 198 to 200, where the inspector sets out in some detail the relevant circumstances and the interest and the nature of the
I see.
the urns and the piers. So,
Because of course they're not there now. So
well, that's the difficulty.
Constructing something.
Any investigation, as the inspector quite rightly pointed out, has to be done on a limited basis. The most information appears to be that, as the court has seen, is in the Sotheby's particulars for the auction, which refers to both the urns and to the piers, as I intervened earlier.
He doesn't address the question of whether they're buildings.
Of course, my lord. However, there is the preceding question of whether the issue of whether they are buildings properly comes before an inspector or the Secretary of State on either a listed building consent or an enforcement notice appeal. But since the court seems to be interested in the latter point, I will take that one first and then come back to the preclusive issue in a moment. I would ask the court to reject the contention by the appellants that building necessarily is to be equated with land, because that is in essence what Learned Friend's submission does. Parliament has, since before year zero, i.e. 1947, even in the 1932 Act, which introduced limited protections, included in the definition of buildings, structures and erections. Not all the definition provisions are there. I've asked for the 1932 Act, which precedes general planning. Can I hand that up? It simply shows that buildings has always had a wider definition.
Thank you, Mr. Westphal.
This is in the Planning Act, not the listed buildings.
This is well, of course, as your lordship may recall, the list of building provisions were always originally in the Planning Act, and they were only separated in 1990.
So they were in 1932 as well.
They were in the 1932 Act, the 1947 Act, the 1962 Act, and the 1971 Act.
Yes, but I think, the point I was, sorry, do you want to?
So I'm just drawing the court's attention so you have a complete picture. This is the interpretation section, section 53. Buildings include structures and erections. It's always had an extended definition.
But I think the thing I'd like your submissions on at some point, or help at some point, is this. In in the Cawthorne case, we find the courts grappling with the simple definition of what is a building and having to deal with these rather tricky questions of fixtures and fittings. And we seem to find the Parliament's response to that in the 68 Act to introduce this extended definition, which is clearly designed to deal with garden ornaments and things like that. And I just wonder, when we're trying to interpret the word the building in its present listed building context, whether we shouldn't be guided to some extent by that, rather than going back to the sort of Barvis type planning approach.
Well, that may be right, my lord, but not for the reason my learned friend has put forward. And it comes out of something that my Lord Sales said when he intervened on what was before the court in Cawthorne. Can I ask you to have the Authorities Bundle, Volume 1, just to remind the court at page 271, Section 1.5, which does two things. Firstly, a listed building is a building on the list compiled by the Secretary of State. And for the purposes of this act, so clear split, you then have the extended definition, and that ends with the phrase, where the extended definition applies, any object or structure, etc., shall be treated as part of the building. It's not a land test under the law as it currently stands. It's deemed to be part of the building. The building is deemed to be a listed building because it's on the list. And
However easy it is to remove it.
Yep. And if one goes back to what Lord Justice Russell said in the Cawthorne case, it's the point my Lord Sales mentioned, although my learned, in fact, it appears in the judgment itself, though not on the pages the court was taken to. If the court would go, please, to tab 11, page 419. Lord Justice Russell sets it out with complete clarity in the last two lines. The real point before me is whether the items in dispute are part of the building, Scarrows Brick Hall. In other words, as my Lord said, the question not whether this was a listed building or whether it was a land, but whether it was land, but whether it was part of an undoubtedly listed building. It doesn't help you with the question of what a building is. It's dealing with something that is undoubtedly
it's
listed.
telling what is part of the building.
And that is what you then see, which is why I began with Section 1.5, with the extended definition test. Because what the extended definition test does in Section 1.5 is to say, objects or structures fixed to the building, that was the argument in Cawthorne, and then you've got pre-1948 curtilage items, clearly defined in that way to prevent items becoming listed by accident post that date, simply by virtue of being erected in a garden of the curtilage of a listed building. But the object or structure within the curtilage is dressed up in terminology of land, the only part of the definition which it is the case, although not fixed to the building, forms part of the land and has done so since before 1st of July 1948. So when Parliament has intended to introduce the concept of being part of the land, it does so, but only in relation to extended definition B.
Yes, but so where does that take you? We've still got to look at it as a single definition, try and work out what Parliament's getting.
With respect, my Lord, no, because Parliament has said there are two ways or three ways something can be listed. One is it's the building included on the list, and I'll come to the definition of building, and I appreciate your Lordship's concerned about that. But two is because it's an object or structure fixed. Three, because it's an object or structure within the curtilage and forms part of the land. And those items shall be treated as part of the building. And the phrase, and for the purposes of this act, makes it clear that he's adding to the definition of building. It's not telling you what building means, but it's telling you that these specific items become part of the building for the purposes of the law with regard to their protection.
Do you know when they brought in the reference to 1948?
Yes.
That case, in 1986 for some reason.
Yes.
Why?
I can take instructions as to why. I've
May
got
not matter.
DCMS officials behind me. I will check over lunch.
Thank you.
But that I say, there's a clear dichotomy between listing and then items which are deemed to be part of the listing. And indeed, one of the issues here is my learned friend, with respect, confuses cases such as chambers, which are on the scope of an undoubted listed item, with the question as to whether you can question whether an item is properly listed in the first place. Chambers was about how far does the curtilage extend, and does a building added to it.
But you
That's-
accept the correctness of Chambers, do you?
Well, I'm not sure that Lord Justice McComb
Well,
accepted
not
the
no,
correctness.
but
I was only-
do you? It's not being questioned, as I understand.
No, all I say about Chambers is, like a number of other decisions, it was dealing with the scope of what was listed, not whether what was listed should have been
Yes,
listed.
but it's a factual question about what was subject
Yes,
to
but it-
control, and it was the judge took the view that it really should have been dealt with within the appeal proceeding.
Well, just as within Barrett's and Ashford, there was a misdescription in the listing particular, and what had to be struggled with was whether that was sufficient to identify the building that had been listed, or whether it wasn't.
But I mean, at some point you'll explain what is the legislative reason for saying that that sort of question should be decided in the appeal procedure, whereas this question can't.
Because as your lordship held in the Court of Appeal in Trim with regard to breach of condition notices, and the House of Lords held in Wicks, it's because Parliament excluded it.
Well, we'll look at Trim.
Well, yeah.
I knew you'd be sort of triggering myself, so that went up.
Yes, I did bring it along. I thought your lordship might refer to it at some point. But the important point is this: as Lord Hoffman said in Wicks, and we've given the references in our case, but I will go to the relevant passages to the extent it helps. It's important to see that Parliament has progressively and more tightly defined the enforcement process and the planning process. And your lordships, my lady, know very well that it's a complex statutory code. You've seen the statements in our statements of case referring to well-known authorities.
I mean, one of the emphasis of Wicks is that you should do these things within the planning process. You get your extended rights under that. You should interpret them as extensively as possible, not bring them into another process.
No, what Lord Hoffman and the other members of the House of Lords said in Wicks was, if it's covered by the grounds of appeal, then it's dealt with at appeal. Otherwise, what he called the residual matters have to be dealt with by judicial review, even criminal issues, because the criminal aspect of enforcement is simply part of the statutory code.
And even if that's wholly unsuitable for the...
Well,
anyway, sorry,
so,
I'll let you get on.
I understand your lordship's concerns on that, but my answer to the first question about Cawthorne and its relevance, I hope I've explained, and the clear dichotomy between listing because it appears in the listed building because it appears in the list, and then the extended definition, and it's only the extended definition that brings in land concepts, and one can see that that aligns completely with what Lord Justice Russell said for the reasons I directed the court to at page 419.
I mean, in fact, subsections A and B are almost equivalent, and A is looking at you've fixed it to the building, which in landlord terms is Cawthorne,
Yes.
it's become part of the building, and B is you haven't fixed it to the building, but you fixed it to the land, which is the curtilage.
Exactly.
And it's part of the building for that reason as well.
Indeed, and all that Lord Justice Russell was doing in Cawthorne was applying those concepts to try and understand whether it was part of the listed building in the light of the law as it stood at that point. Parliament has rewritten that, although not in a
But
manner
very
which
much-
clearly is reflective of what Lord Justice.
Yes, very
Russell
much in
said.
line with.
Indeed, it
Justice
uses the language that he uses himself.
But Parliament could have chosen simply to use the word fixture,
Indeed.
but didn't.
But it didn't. The other point, this is picking up my Lord Sale's first point, of course, it uses the word objects. It doesn't use chattels in contradistinction to land or building. It uses objects or structures fixed to the building. It distances itself, in my respectful submission, from landed concepts, except where it expressly refers to them. The protection of listed buildings, in my respectful submission, is not directed simply to matters which are treated as land in the sense my learned friend seeks to explain, but seeks to protect a whole wide variety of items, to use a neutral phrase. The very definition building includes structures and erections. Parliament has not chosen to use land or fixtures in the property sense, but buildings including structures and erections. And I've shown the court that has been so from a very early stage. The definitions of buildings, in fact, first came in, the definition you see in section 336 came in the 1947 Act, and it has remained almost unaltered since then. So it's a constant wide definition. It is clearly understood by the Secretary of State and Historic England to include structures which are not land in the traditional or property law sense. Can I take the court to the letter from Historic England at the end of the core volume that the learned friend touched on briefly?
$230.
Yes. No. 250. I think. Thank you. That's it. 250, 251. 250, 250, 251. The letter from Historic,
Yes.
13th of December. The assumption and the reasoning of Historic England for setting out its position is to treat the grounds that those items are structures. And you see that in the second paragraph on page 251. The grounds for listing these structures was the same as for any other listing, namely in accordance with the legislation considered to be special architectural and historic interest. Many garden items, as well as structures such as buildings relocated in open-air museums, including statues and urns, have been listed after they've been moved because they still qualify under that definition.
I mean, do we find anywhere, I was looking for this, any guidance from Historic England as to where they draw the line between things which are buildings and which aren't, when you're dealing with things like statues or garden urns? Or, they must have, I assume, some sort of criteria.
Well, I'm not aware of there being any as such, other than the fact that you've got two examples of its listing selection guides in the volume 2 of the bundle. You've got gardens and park structures that you've looked at in part
Yes.
at tab 38, beginning at page 894. And there are sections that I'd just like to draw the court's attention to because it's relevant to this issue. The document, of course, is called Garden and Park Structures. So it does tie into the language of the statute. And the introduction on page 897, and it says, this selection guide is devoted to individual built structures found in gardens and parks.
Sorry, where's that?
It's the introduction, my lord, 897. It's the very opening words of the introduction. Is devoted to individual built structures found in gardens rather than the designed landscapes themselves.
Yes, so it's accepting they've got to be built.
Well, if you then, well.
No, I mean, I'm wanting your help, Mr.
Yeah, no,
because
I know.
Having been in this game quite a long time,
Yes.
I've never come across a very satisfactory assistance as to where you distinguish between a vase or something which is movable and is not a building, and something which is.
Well,
without,
Yes. Well, Lord, I hesitate to describe as a vase something which is 9 feet tall, but I suppose.
No, but I mean, there's some things, forget about the facts of this case. There must be a line to be drawn somewhere. Would you accept?
Yes, there must be.
What are the criteria?
But you're dealing in this guidance with structures of some substance, and you'll see the last sentence of that introduction. This selection guide helps identify which structures meet the test of special interest for listing. And it deals with matters of a variety of types. The court has seen the section on statutory urns and other features such as sundials and astronomical devices. And clearly the view is taken that matters such as these, which were placed in formal gardens, even though they may have been moved, as we see at the top of page 907, are capable of listing, particularly pre-1850 items. And in response to the question that was asked earlier, the photograph of Rest Park on page 902, the statues are separately listed. And indeed, the sundial at Rest Park is separately listed. If the court wants a list of the items on the list for Rest Park, I can have that provided. But in fact,
But if you say
all you have to do is to search Rest Park on the listing items online.
We'll do that for ourselves. If
Yeah,
we
well,
want to.
the link is in our statement of
Very
case.
well.
Yes. And other items that you see which are not dissimilar, the Henry Moore statue, for example, on page 903. Clearly, items of some substance, of a decorative nature, are regarded as of listable quality. And it has been the case, in my respectful submission for many years, that Historic England and its predecessors have listed or have advised the Secretary of State to list items which might not be buildings in the traditional sense, but could be regarded as structures, even though they're not attached to the land in the formal sense, but are matters of some substance, as these urns were.
But help me, I mean, in this case, if Mr. Diller had been able to raise the question of whether this was properly regarded as a building, are you saying it was obvious that it was, or that this would have been a question which was open to?
A matter of items of this substance and this scale, I would say it was obvious it was a structure.
Or has that ever been said by the Secretary?
No, because it's never been, it's not been run as a discretion argument.
But it was. Mr. Dill raised in his grounds of appeal that these aren't buildings, and it simply wasn't addressed by Historic England.
Well, the inspector addressed it by saying this was not an issue for him, and
I know.
that will bring me.
I think the first time anyone has actually said on behalf of the Secretary of State they think this is clearly a building is when you said that a moment ago.
Well, it's entirely consistent with Historic England's approach in its selection guidelines. It is entirely consistent with the statutory definition, which includes structures as well as buildings in the traditional sense.
But am I right in saying that's the first time that's been said on behalf of the Secretary of State?
Yes,
And you're saying it on instructions?
I will make sure that they are instructions. But Historic England, which is the Secretary of State's advisor, as you see in the letter that I referred the court to earlier, regarded it as an appropriately listed structure. That is entirely in line, and the reason I draw your attention to the listing guidance is entirely in line with the listing guidance. For the completeness of the matter, it's also worth noting that other forms of what one might call as not commonly regarded as building structures are included, for example, funerary monuments and the like, and you have the commemorative structures guidance at tab 37. And again, even gravestones may be listed, and examples given on page 882. They are of historic importance in some instances because of the information they convey. Public statuary on page 884, and various forms of war memorials. There are very many war memorials from, particularly from the First World War, which are listed on the statutory list. It won't surprise the court, this is mentioned in our statement of case, the cenotaph in Whitehall is a listed structure, though no one would describe it as a building. Clearly of considerable substance, and I'm not suggesting it's comparable to
But it's certainly a structure or erection.
but but even monuments of a lesser degree, and you see it.
No, I mean, you know, I can see that the cenotaph is clearly a structural erection.
It's not a good example.
It doesn't help as to whether a vase is a structural erection.
As I've submitted, structure does not carry with it land connotations, but something wider than that. And you see how it's approached by Historic England, and it's treated these in the same way in that letter that I've shown to the court. Can I, at this point, also draw attention to the fact that in the context of the list, the courts to date have regarded the fact that an item appears on the list as being determinative of its being a listed building. There is scope under the grounds under listed building consent and enforcement notice to challenge whether it's of special architectural or historic merit, but not, we submit, and I'll go into details after lunch, as to whether it can be challenged on legal validity grounds. The relevant, without taking the, troubling the court with the relevant authorities, there are statements by Lord Hope in the City of Edinburgh, Lord Hope in the Shimizu case, and Lord Mackay in the Debenhams case, and Lord Justice Mummery in Barrett and Ashford. They are set out in our written case in paragraph 30, and I don't need to repeat them, but the references are there.
Are those comments made in the context of a party saying, I want to challenge whether it's a building at all?
Well, in Shimizu, the question was part of a building, a chimney and fireplace that remained. It was not the direct, the issue was whether it was included within properly to be regarded as the listed building or the building. And in Debenhams, for example, it was a curtilage issue. So it wasn't directly the issue in this case. And this is the first occasion where this issue has arisen directly.
Indeed. Thank you.
But there are circumstances in which issues were raised in Shimizu as to whether the part of a building definition in section 336 continued to apply once the building had been listed. And what their lordship said in Shimizu was the question of whether it's part of a building is considered at the stage of listing. And if you list only part, then that is the listed building. But if you list the whole building, that is the reference point for section 7 and section 9, and then for other matters under the provisions. So it has come up as a legally relevant issue, but in slightly different contexts, but closely related ones. And the other point, which Lord Justice Mummery made in the Barrett case, again referred to in the same section of our written case, is it's an essential starting point for the public, because the public can discover whether something is listed, at least in outlined or broad terms, by consulting the register, and indeed consulting the planning register, where the listing is registered as a local land charge. I don't know whether that's a convenient moment.
If it's convenient for you, it's convenient for
indeed.
us, Mr.
Could I
Melvin.
just ask a quick question?
Of course, Madam.
When you move an item which is a structure and which has been listed, is there any process whereby the local land charge moves to the place where it's moved to?
Yeah, I think it will depend. I'll need to check. It will depend on the terms in which the land charge is described. But moving a listed structure, if I can call it that, would be a breach of section 7 without listed building consent.
Yes.
Because it would be at the very least an alteration, because you'd be moving it from one place to another. So it's controlled. And so if a listed building consent were granted which allowed its movement, then that would in due course go into the register as a listed building consent.
Excuse me. That's it for today, everybody. I got to change the schedule around a little bit because I didn't like the way it came out, but I'm going to be working on that. Yes, I go live every day at 3 o'clock p.m. Central Time, 4 o'clock Eastern Time. Do me a favor, guys. If you like the content that's on this channel, please consider subscribing to this channel and helping this channel grow. You all have a wonderful evening. Ta-ta and ciao ciao, and I will see you again tomorrow. Have a good one.
Daniel. You're my solid ground, always drawing near. Never give up on this heart of mine. Put it back together every single time. To all you do, from the highest peak, I can see it through. With your care and touch, everything's